Good morning. We're going to start in 1 or 2 minutes. We're giving another minute to the participants to connect. Good morning. Good morning and welcome to Paris Arbitration Week 2022, which is our 6th edition. We have a lot to cover this morning, so let me get started immediately. As some of you will know, my name is Yasmin Mohammad, a Persian through and through, a Sorbonne graduate, an arbitration practitioner for the past 20 years, and I have the honor of presiding the board and the organization committee of Paris Arbitration Week. There would be no Paris Arbitration Week without the hard work of all of the board members. So let me introduce them to you. Our Secretary General to my right, Alex Fessas. Our Treasurer to my left, Clément Fouchard. And down the table, our PR and marketing team, Marali Paralika and Claire Poli. Our events team, Raphaël Kaminski and Sabrina Inouz. Our partner relationship team, Johanna Tudornol and Ben Sino. And our absent but very important PR consultant this morning, Amélie Lerosier, which has been a support from day one. Thank you all. POW is also the fruit of the unwavering and ongoing support of the 4 founding Parisian institutions you all know very well: the ICC, Paris Place de l'Arbitrage, Comité Français de l'Arbitrage, and Association Française de l'Arbitrage. A special thank you today to the ICC for hosting this kickoff event in their state-of-the-art facilities right here in Paris. We have 71 POW partners this year, including law firms, experts, funders, translation companies that contribute their rich and challenging events to the week. This is our biggest year ever. And the energy and the desire to meet after these past 2 years that have been impacted by COVID is palpable. Thank you to the many universities and arbitral institutions, associations that participate to POW every year and enrich our program. Despite the excitement of a full POW post-pandemic, we are not turning the other way and ignoring the catastrophic situation in Ukraine. As you may have noticed, POW has partnered with the Red Cross, and a specific POW link to donate is available to you every time you sign up to a POW event. If you're wondering how your money will be spent, as you should, the Directeur Général of the Red Cross, Jean-Christophe Combe, has agreed to answer that question in a video specifically prepared for POW that is available on our social media accounts and the website. POW is no longer about Paris, and throughout the pandemic, we have noted just how global POW has become. In 2020 and 2022 and 2021, we noted that each year we had double the attendance to the various POW events with participants from all regions of the world, thanks to the online format. It was very important to us this year to continue making POW accessible to the greater number. This year, for the second time, we have an increasing number of non-Paris-based firms and experts and institutions who are participating in POW, which is really a testament to POW's reach and role in the world. POW is not only about Paris anymore, and it's not only about the Parisians anymore. It is about connecting the world of arbitration, of the international arbitration practitioners. We have a very busy week ahead of us. A total of 114 events are taking place this week in Paris. 42 hybrid events, 30 exclusively virtual events, 21 exclusively live events, excluding cocktails and parties, and brace yourself, 21 cocktails and parties appearing on the official calendar in 5 days, Monday to Friday. To follow the week, please check out the calendar on our website and follow our LinkedIn. We have just under 10,000 followers, 9,938, but who's counting? And we're looking to increase that again this year. As we start the week, we are already thinking about 2023. So please take out your calendars and note the following. POW 2023 will take place the week of the 27th of March. Ahead of that, the next POW General Assembly will take place on the 6th of July at 3 p.m. CET, so our American friends can join us. And during the next General Assembly, the elections of the 3 new board members will take place. So I guess this kicks off the campaign. All of you thinking of joining the board, please reach out to the voting members during the week. And now we get to the moment you have all been waiting for. This year, we continue a POW tradition by inviting a Parisian luminary to address the POW audience on diversity in a transversal, scientific, challenging, philosophical, or sociological way. In staying true to our commitment to diversity in all its forms and convinced of the real benefits of a diverse environment, POW has decided to keep diversity as a topic of the keynote for as long as diversity will be an issue that appears as complicated to tackle and address. We are honored that Mélanie van Leeuwen has agreed to represent us this year and has agreed to deliver the keynote speech. Mélanie requires no introduction, and the list is very long, but let me have a go at introducing her properly. And now Mélanie is worried. Mélanie's fait of arms in international arbitration are quite well known to all. She is one of the most in-demand arbitrators of our generation in both commercial and investment treaty cases, whilst keeping a very healthy flow of cases counsel. She's the chair of the ICC's very unique think tank, the well-known Commission, which comprises of over 1,000 professionals from across the globe that contribute to the various working groups and scientific output. I went online and I started reviewing the accolades and the online commentary about Mélanie, and I came across the following adjectives: Dutch superstar, powerhouse, sharp, fantastic, excellent, profound, outstanding, and extraordinary. Having known Mélanie for almost 20 years, I can share what legal directives don't capture. She is fiercely courageous, but always thoughtful. She is genetically bold, but constantly tactical. She holds herself to the highest standards of ethical conduct, but as a friend, she will always have your back and she will never let you get away with bullshit. Welcome, Mélanie.
Thank you. Thank you to the Paris Arbitration Week Organizing Committee for inviting me, and thank you for your nice introductory words. So when I was asked to deliver this speech on diversity, indeed, I said, isn't that the topic that Eduardo Silva Romero addressed last year? And the answer I got struck me. Indeed it is, but the POW Organizing Committee has decided that this will be the topic of the keynote address until it will no longer be an issue. So bravo to the Organizing Committee for its ambition and commitment. So we better get down to business because there's quite a bit of work to do before we get to that point. What I want to discuss with you today is the proposition that diversity is not a matter of choice, it's a matter of necessity. on which the future of arbitration as a self-standing means of dispute resolution depends. Inequality and discrimination are as old as humanity. The moment people started to accumulate wealth, inequality came with it and power over those who don't have any property. Property engenders power, and those who have power like to concentrate it in the hands of like-minded people. That's how we're wired. It's in our DNA. During the 20th century, much effort has been made by governments to redistribute and to reduce the inequalities compounded by the Industrial Revolution. Irrespective of race, gender, class, people were given the right to vote, social protection, access to education, healthcare. So the rationale of those policies was that equal rights and opportunity would lead to economic prosperity of populations and societies at large. Now we fast forward to the 21st century. One of the most empowering means to exercise the power, the right to equal opportunity has been the internet. Information empowers. People in the most remote areas in the world can follow what happens around the globe. In China, Zimbabwe, in Iran, in the Netherlands, people can follow and participate today in the Paris Arbitration Week. The internet bridges the gaps between people and businesses. But while globalization and the internet have united the world horizontally, it may also have divided it vertically. It's 2022 today. More than ever, we live in a globalized economy, a globalized world where everything and everyone are connected. The COVID pandemic, climate change, a vessel blocking the Suez Canal, the invasion of Ukraine by Russia. Although none of these crises have originated in our home country, they very quickly affected the everyday lives we live and the manner in which we conduct our business. Supply chain issues, food scarcity, increasing prices of energy, primary materials, we're all connected. And we no longer have the luxury of thinking, well, that's terrible, but at least it didn't happen in my backyard. This week, the international arbitration community is gathered in Paris. Our community is tasked with the resolution of the disputes that the global economy generates. Arbitration as an organized form of dispute resolution has been around for some 150 years or so. It's consensual in nature, we all know that. It is based on the voluntary submission to the jurisdiction of an arbitral tribunal, and thereby the parties waive their fundamental right to access to the justice system afforded by law. The legitimacy of arbitration stands or falls with the trusts that the users place in the decision makers, the quality of the process that they conduct, and the fairness of the decisions that they render. Our task in the administration of international justice comes with tremendous responsibility. However, over the last 150 years or so, that responsibility has largely been exercised from the calm and the comfort and the confidentiality of private hearing rooms. With the onset of the internet, and once the public at large found out that sovereign interests were being decided by private arbitrators in the context of investor-state disputes settlement, the system of arbitration itself became the subject of scrutiny and public criticism. The indignation about the confidentiality of arbitration, a feature that was once used, or it used to be one of the very valued tenets of arbitration, it caused public outrage in the setting of ISDS, and understandably so. Because public scrutiny was about to compromise the system, the trust of the user, and the legitimacy of the system, transparency initiatives were launched to safeguard the credibility of arbitration, not only in the investment treaty setting, but also in the commercial context. In addition to confidentiality being called into question, public criticism also focused on the very limited and homogeneously composed pool of private judges who decide the large majority of international disputes. And within the arbitration worlds, there are different views as to whether that perception is right or wrong. However, ignoring it is not an option. The reality of today's globalized world is that the public expects to see a reflection of its own diversity in government, in business, in media, in boards, and in the judiciary. Of course, arbitration is no exception to that development. Why would it? Therefore, in order to keep confidence in the system, in the administration of justice through arbitration, and for the system to be perceived as legitimate by the public at large, we have to ask ourselves the questions whether the international arbitration sector reflects the world whose disputes we resolve. Now, without having to dig too deep into detailed demographic statistics, with roughly 60% of the world's population living in Asia, 50% of the world's population composed of women, and some 15% of the world's population being affected by some form of disability, I think we can instantly agree that the world of arbitration does not yet mirror the world whose disputes it resolves. Ladies and gentlemen, diversity is no longer nice to have. It is a dire need, without which the system of arbitration won't be able for much longer to keep up with the expectations of its users. But the good news is that the arbitration sector embarks on the diversification process from a prime position because it is already diverse in nature. It brings together parties, lawyers, arbitrators, service providers from different countries. They apply different sets of rules. Different is the standard in the international arbitration world. Navigating all those differences not only requires solid knowledge of the law and the case file, but it also requires interpersonal skills, judgment, a certain level of gravitas to conduct the proceedings, and most importantly, it requires an open mind. Open-mindedness is probably the most indispensable feature to make the arbitral process work and to overcome cultural and legal differences that we meet on the way. And this is where it may get a little tricky. Of course, we're all convinced that we're open-minded, yet each and every one of us is biased in our own ways. We all see the world and approach our business through our own frame of reference. We gravitate towards people like ourselves in terms of appearance, in terms of education, in terms of social background, in terms of professional experience. So let us stop thinking that the others are the problem. We are all loaded with forms of bias. So the bad news is, you are the problem. I'm the problem. We are all responsible for, and we perpetuate the flaws in the system. This makes us all responsible too for fixing the flaws. Now, how shall we go about that? The first step that we need to take to fix the system is raising awareness. And with the Paul Board's ambition and initiative in mind, we cannot afford to stop reiterating the importance of diversity and inclusion until it no longer is an issue. In that context, we need to ask ourselves, where does the lack of diversity come from? The obvious answer is party autonomy, another valued tenet of international arbitration. When asked to select an arbitrator or counsel for a bet the company case, we all start looking in the circles of people we know, like-minded people. We're looking for predictability. We look for professionals in whom we can trust. People who have received a similar education, similar professional experience, who go about decision-making in a way that resembles ours. And in that process, we rely on the information and experience of other valued colleagues who more often than not resemble us. Now, as the saying goes, because no one ever got fired for buying IBM, for important cases, in-house counsel, arbitrators, arbitral institutions, they will always seek out senior arbitrators with a gilded track record, stellar rankings, who are necessarily part of the international arbitration establishment. And because no one is against diversity, or at least not openly, we reserve our noble diversity efforts for smaller cases, less complex cases, lower value cases. In those cases, we may be convinced to entrust the arbitration to a woman, to a younger arbitrator, to a professional from a different ethnic background, or to a differently abled person. Does that sound familiar? When I query colleagues or clients in the selection process about the lack of diversity on the list of candidates that they consider, I routinely hear, well, there simply are no suitable women, or there are no other arbitrators available in that region with the right qualifications for this dispute. Of course, diversity cannot come at the expense of quality. Again, does that sound familiar? Let us not kid ourselves. That's a lousy excuse, an excuse that is not in fact rooted in the available talent, but in our lack of effort and willingness to look beyond the circles we're familiar with. The real question is by what standard suitability must be defined, and whether those outside the relatively homogeneously composed international arbitration establishment can simply be dismissed as non-suitable. As lawyers, we're trained and we're paid to ask questions, to be rigorous, to research, to verify. We can apply that same rigor in the selection process of counsel and arbitrators. The internet offers unrivaled tools to identify and to contact potentially suitable candidates. And a good faith effort will show very quickly that there's plenty of talent out there and that the pool of suitably qualified arbitrators is much larger than we think or simply assume. So the right question to ask is, the person that I have selected for this case, do I feel comfortable with that person, or is that person objectively the best qualified for the job, for the matter? That brings me to the second step that needs to be taken in order to make real progress. We need to focus on the benefits of diversity. We need to get away from this guilt-induced approach that diversity is the morally right thing to do. Of course it is, but the fact of the matter is that diversity comes with hardcore, quantifiable benefits. Let us start with quality. In my experience, quality sells. There's ample sociological research that proves that diversity improves the quality of the decision-making process and its outcome. Diverse groups, which of course includes arbitral tribunals, make better, more balanced decisions and systematically outperform homogeneously composed groups. Why is that? There are three reasons. First, because diverse groups focus on facts. Shared assumptions come with shared blind spots. Like-minded people are subject to the same cognitive bias, and as a result, they have the tendency of thinking in the same way. They adopt the same thinking modes. They have the same beliefs that leads to the pursuit of less rational courses of action, self-righteousness, and delusions of certainty. Because members of a diverse group do not share the same social code and reference. They focus on the relevant facts, which greatly reduces the risk of group thinking. The second reason, because diverse teams process facts more carefully. Those who have represented clients in setting aside proceedings, they will recognize that often large portions of the evidence have not even been addressed by the arbitrators in their awards. Because there is no shared frame of reference and values. Diversely composed groups examine a wider array of information and they process facts more carefully and more systematically. Because people who are differently trained ask different questions, they systematically challenge each other's views and force each other to test the relevant facts and consequences from different angles. Questioning the assumptions and views of others will require them to justify their own conclusions. The members of a diversely composed tribunal will feel less comfortable than the members of a homogeneously composed tribunal. They will have to work harder to get to a decision. But who cares? They are service providers. That's what they're paid to. That's their job. And they have every interest in doing a good job. Now, the third reason why diverse groups do better, and those flow naturally from the first two, is that a diverse group generates a better work product. Because cognitive and cultural diversity leads to a more balanced process and a more comprehensive analysis of arguments and available evidence, the quality of the decision is likely to be better. As the quality of decision-making increases through diversity, so will the user's confidence in the legal system. Litigants will be more likely to be satisfied that they had an opportunity to be heard, and they will respect the outcome of the rule of law applied in their process. So diversity enhances legitimacy. Now, cynics might say, it's not my job, as the one of arbitration user, to salvage the legitimacy of the system. It's my job to win in this case. We can all relate to that objective. But ignoring the importance of diversity is short-sighted because it can lead to public policy concerns about the legitimacy of the award. And as we all know, public policy may compromise the enforceability of the award. So from a business perspective, the worst possible outcome is that all the time and the money invested in an arbitration would be wiped out by an annulment of the award or a refusal to enforce it. But as the cynic is also unlikely to be convinced by anything else than self-interest, the ultimate question that we need to ask ourselves is, what's in it for me? Let us answer that question for the main stakeholders in arbitration. And I've identified 4 categories: the user, the arbitral institution, the outside counsel, and the arbitrator. So what's in it for the user? The clear answer is the better product. If diverse arbitration is on offer and leads to a better quality award, how can you possibly justify to your board, to your shareholders, to your stakeholders that you opted for and invested significant time and money in a B-quality process, that you contented yourself with the engagement of a homogeneously composed counsel team, and that you selected arbitrators from an ultra tight, small group, busy people who routinely sit together? That is simply indefensible. Now, what's in it for the arbitral institutions? On the international plane, arbitral institutions carry the responsibility for access to and the administration of justice. That responsibility is comparable to the responsibilities of the Ministry of Justice, of the judiciary in the national system. It's an enormous responsibility towards the international business community. In addition, international dispute resolution is a competitive business. If you do not ensure that your arbitral tribunals are diversely composed and render grade A quality awards, your competitors will. It is then only a matter of time for the market to recognize that the competition's awards are of a superior quality, which will subsequently drive the user's decision as to where future disputes will be resolved. Now, what's in it for counsel? In the short term, your objective is to win the case for your clients. In the long run, your objective is to build a track record that will enhance your reputation as a successful arbitration counsel and to attract more business. If you don't recruit lawyers and bring in team members from diverse backgrounds, your opponent will. Because of the multiplicity of perspectives and the richer input that the opponents benefit from, there is a considerable risk that their team will outsmart yours. So arbitration lost and your track record development on hold. Now, what's in it for the arbitrator? The arbitrator is appointed by the users, by counsel, by the institute, or by a combination of those. So one could take the view that the arbitrators only have a peripheral responsibility in the diversification process, but that would be an error. In the large majority of cases, co-arbitrators play a role in the selection of the presiding arbitrators. They are asked to select the president themselves or in consultation with the parties. Through the candidates that they suggest and the opinions that they express on the identified candidates, they can play a role in the diversification process. But do they? Do arbitrators suggest names from the small pool of colleagues with whom they routinely sit? Or do they look at the characteristics of the disputes, identify the factors that are relevant to determine the suitability of the presiding arbitrator for the concrete case? And do they map the field of potentially suitable candidates? Getting back to my earlier point that an open mind is indispensable for an arbitrator, that open mind should not only be applied towards the consideration of the issues in dispute, but should equally be applied to the composition of the tribunal, so that the users will get a tribunal that's capable of delivering the prime quality awards that the litigants expect and need. Now, to conclude on the question, what's in it for me? Quite apart from the need to tick the diversity box and to be able to report that you live by the policies that you preach, there is a clear business case for diversity for all involved in the arbitral process. And if you do not deliver the prime quality that diversity and inclusion generate, others will. Now, having addressed the first two steps, awareness and benefits of diversity, the third and last step that needs to be taken is action. It's often suggested that diversification is a natural process that will take time and that we need to let the process run its course. Where are we today in that process? In the mid-90s, when I started working in the international arbitration world, apart from the court reporters and the interpreters, I was always the only woman in the room. The arbitrator pool was exclusively made up of middle-aged, not to say elderly men, white men. In fairness, a lot has changed since then, and arbitration has made serious effort to diversify, or the arbitration world has made serious efforts to diversify the arbitrator pool. As of the early 2000s, arbitration institutes started appointing younger lawyers in order to give them a first opportunity at gaining experience and build up a track record as arbitrator. 10 years later, around 2015, the members of the arbitration community came together and launched the Equal Representation in Arbitration Pledge, with the aim of increasing, on an equal opportunity basis, the number of women appointed as arbitrators in order to achieve a fairer representation in the short term and full gender parity in the longer term. At that time, 2015, we're talking, around 12% of the arbitrators was estimated to be female. Today, I think we have the statistics for 2021, only at the best performing arbitral institutions has there been a doubling of that percentage to around 24%. While that growth rate over 6 years may look impressive at the first glance, we should not ignore that in absolute terms, only a very limited number of female arbitrators take care of those 24%. As a result of the ERA pledge, change did occur. Pressure was put on the arbitration community to do something about the overrepresentation of men and the underrepresentation of women. Pressure was on the institutions, on the law firms, on clients, not only to sign the pledge, but to report on how the pledge undertaking was being implemented in practice. And while many of the leading arbitral institutions have significantly increased the number of women they appoint, the reality is that party appointments, which make up the majority of all arbitral appointments, still lag behind, far behind. As of January 2021, regional and ethnic diversity has also been placed on the arbitration agenda. Under the motto, let's get real arbitration, the arbitration community has come together again in a movement that is called Real Racial Equality for Arbitration Lawyer. So far, unfortunately, we have only witnessed shy attempts towards ethnic and regional diversity and not seen the arbitration community rally around the real initiative in the way it had embraced the ERA pledge. The real initiative is just as worthy of our support as the call for gender diversity. It is, of course, absurd that a handful of Europeans and North Americans get to decide commercial and investment disputes throughout Africa, Asia, and South America. In order to ensure a real understanding of cultural diversity, both legally and commercially, the obvious solution is to appoint arbitrators who have the roots in the relevant jurisdiction. Now, lastly, as recent as January of this year, the inclusion of professionals affected by a disability, or better put, differently abled persons, has been put on the agenda. The ICC Commission on Arbitration and ADR has dedicated a task force to it. It has the mission to enable disability inclusion, raise awareness of the issues faced, and identify the adaptations that can be made to accommodate those with specific needs in order for them to do their job within the international arbitration sector. The lack of diversity is a global issue that requires a global response. However, the arbitration sector is a decentralized sector with many different actors and many different interests. So the power to fix the issue is unfortunately fragmented too. Although some progress has been made on age and gender diversity, the diversity spectrum is wide and requires careful consideration and action by all. That affirmative action is urgently needed is reinforced by the fact that the arbitration community is already years behind the judiciary in many countries. For example, the Nordic countries, which realize that litigants who are using the justice system expect to see a cross-section of society reflected on the courts, and they diversified their judiciary accordingly. So in order to avoid compromising the system and to achieve a well-balanced, diverse arbitration bar and bench, each of us has to start taking responsibility for diversity and inclusion within our own cases, within our own firms, within our own departments, within our own company, within our own institute. Just like with climate change, it's not an option to wait and see how others solve the issue for us. Because if we do, we will all risk drowning together before an adequate solution is put in place. We don't need lame pronouncements of grand principles. We need pledge-like commitment and affirmative action towards diversity goals and regular reporting on the progress made towards those goals. In the Netherlands, we say, improving the world starts with yourself. The fact of the matter is that if we, if you, if I fail to take our responsibility and bring about the necessary change, it's unlikely that international arbitration will be able to meet the demands and expectations of its users for much longer. Now, in memory of Madeleine Albright, who sadly passed away last week, I would like to close with her famous statement she made in the context of the emancipation of women. There is a special place in hell for women who don't help other women. Same applies to arbitration lawyers. Arbitration lawyers who do not help other arbitration lawyers to seize their opportunity, to participate in, and to make a contribution to our inspiring, fascinating, and diverse international arbitration world, they do not deserve their place at the table. Noblesse oblige, the arbitration community needs each of us to think outside the box, to go the extra mile, to get outside our comfort zones. We need to invest time and we need to work hard with people outside our known professional circles. If each of us plays their part, I'm confident that we will soon have diverse tribunals delivering higher quality arbitration and awards. And then diversity will no longer be an issue. And the Paris Arbitration Week can move on to the next pressing topic. Thank you.
Thank you very much, Mélanie. A very inspiring speech. I am going to be quiet for a moment and remind the viewers that they can ask questions in the chat box in the Q&A section, and turn to my board members, my board members and friends, and ask them if they have any questions for you. I see Alex.
I'm happy to go first. Thank you, Mélanie, for sharing your thoughts and for carving a pathway for joint perspectives, hopefully. One of the points that I found quite striking is your recommendation for pledge-like undertakings, affirmative action, and reporting. Now, out of those three, we have perhaps the first in at least one main iteration done. We have some reporting, but not much. And as you said, not really a challenge for arbitral institutions, but primarily firms, it seems. And we don't have a lot of affirmative action. Would you like to give us a bit more insight with regard to how you would see these three things advancing further?
Yes. Well, I think the problem really is that if we take the success of the Arab pledge and how it helped the diversification of the arbitrator pool and bringing in women as arbitrators, there was a private initiative that was taken, and it was communicated very well. It was spread around the world very well, and the people who initiated that, they managed to get on board the institutions. And of course, they also made their clients sign those pledges. But you are right that the reporting afterwards is done by a handful of arbitration institutes. The leading institutes make a real effort. And I have to say, probably the ICC, in fairness, has led the way when the ICC court overnight was adopted the principle of gender parity. That makes a huge difference because the court plays a big role in the appointment of arbitrators going forward. The point is that there's only so much that the institutions can do. A lot is the responsibility of the parties, the in-house counsel, but also a lot of the responsibility is with the firms, because they also have to grow a pool of arbitrators that is sufficiently diverse for institutions later on and for their clients or the clients of others to appoint these people as arbitrators. So it is a multifaceted problem. And I think that it's a difficult problem. And there are too many actors in the arbitration world who just take it and leave it to others to deal with. And that's what I mean. We need all to take affirmative action. We need to see what within our world, within our professional setting, we can do to improve the diversification of the arbitrator pool. And I mean, when I say it, you know, the changing the world starts with yourself. And I cannot change the policies at a different firm, but I can speak to my own partners, I can speak to my own clients, I can speak to the arbitrators with whom I sit in tribunals and make my effort. So that is my answer.
Thank you. Thanks very much.
I think there are two questions.
I am checking the question box. I don't know if everybody can see it, but thank you. I had a further comment and a question for you, Mel. One of the things that strikes me as illogical very often is in my role, my paying job, not this one. I'm confronted with situations very regularly where the underlying claimants complain a lot about the time it takes for awards to be rendered, for the apparent lack of focus and time and effort that arbitrators put in their awards because they very clearly did not review certain sets of facts or evidence that was presented to them. And that necessarily comes down to their choice of arbitrators, which is comes out from a very small pool of candidates, which are de facto extremely busy.
Mhm.
And so when I put the question to them, but why aren't you choosing
Somewhere else.
from a different pool? You don't have to choose 89-year-olds, men or women, by the way, to run your cases, and the answer is obviously the IBM answer. You never get fired for choosing IBM, but that's where the conversation needs to take place at a board level, at companies and underlying users, to say, we need to realign our expectations of the arbitral process with the actual choices of arbitrators that we're using. And if I don't choose one of the top, arbitrators that already has 60 ongoing arbitrators any given year, then that's a company choice. And so that's an undertaking companies can make. And that's a deal law firms and their clients can make together. There can be a decision by the board to the law firm saying, we want arbitrators who are going to focus, who are going to do their job, and who are going to deliver their awards quickly, and therefore come to us with a much larger pool of potential arbitrators to choose from than the 20-15 names that we see regularly. And similarly, law firms can agree with their clients, and the clients can undertake to accept to choose from purely anonymized CVs. I mean, one of the biggest biases that we have is that when we see a name, we immediately have a cognitive bias as to what we imagine. And whether it's name or ethnicity or whatever it is, or man and woman, and going with this anonymized CV takes that off the table immediately. And if it's an agreement, it's an undertaking by the law firm to do that and the client to accept it, then it's another way that affirmative action can take place.
Yes.
I can add something. First of all, thank you very much, Mélanie, for a very inspiring speech. I wanted to make a bridge with Eduardo's last year's speech, and something which I keep in mind from his speech was he was speaking about the young generation, about taking in your teams in the law firms, diverse interns, diverse young associates, in order to create this pool of arbitrators that we are looking for. And I know
And promote them.
Promote them. And I know that you are very sensitive to that, just taking a step back and looking at how we actually bring together more variety in this community.
Yes,
Starting from the beginning.
Yes,
actually.
yeah. Certainly. Well, it's clear that if the pipeline leaks, or if the pipeline gets stuck somewhere, the pool is not sufficiently diversely composed. And that is, I think, an issue for society at large to tackle, how the participation of all groups within society in the workplace is facilitated. And if you look at the intake in the legal profession, we always hear that more than 50% of the legal profession is composed of women. That's a focus on gender diversity. There are a million other forms of diversity on which we have very few data. A lot of forms of diversity, of course, come also with issues of privacy. We need to consider sensitive data that cannot just be collected and processed. So it is clear that the challenge as such is not an easy one, but I think on a case-to-case basis, we can work our way through with goodwill and a positive attitude to give others an opportunity, and to make sure that talented practitioners do not drop out of the development path over time.
Another point that you raised, Mélanie, that is fundamental to the issue of addressing diversity is the fact that we've only very recently started measuring the problem.
Yes.
It's only very recently that the arbitral community and thanks to the institutions, really,
Yes.
we've started measuring the problem. And thanks to the fact that we started measuring the problem, we can now measure the improvement, which is also fantastic. But unless we start measuring what's happening, whether it's just on appointments or on hirings or in the way arbitrators choose their presiding arbitrators, unless we start measuring it, we're not going to see if there's a difference because everybody's looking at it from their own biases or their own limited personal experiences. So the more transparency we bring, the more measurement, the more we publish those measurements. And the institutions have already done a great job doing that, but maybe we can start measuring whether co-arbitrators appoint diverse presiding arbitrators. Maybe Jus Mundi and their arbitrator profile can start noting who two our co-arbitrators have appointed as presiding arbitrators, and we can start rating that. I mean, there are different ways in which we can start showing what's done. And because we are all very uncomfortable with the more transparency, but the more transparency we bring, the more we see what's happening, the more we recognize it. I mean, I cannot tell you how many times I've had a conversation with people telling me that gender diversity is no longer a problem. That gender diversity is no longer an issue that needs to be tackled, that we really need to move on to other types of diversity. Not that we don't, obviously we do. But thankfully, now that we're measuring gender diversity, we know that even in the law firms that we all work and worked in, there's still a 20% pay gap between men and women doing exactly the same jobs. That's a huge, significant economic difference in the lives of these women. And so the more we measure, however uncomfortable it may feel, the more we will know and the more we can improve it, in my view.
Yeah. Well, the thing is we talk a lot about bias, but the thing is and I like the fact that you've mentioned that everyone is biased. It's just that we tend to forget that.
Yes.
Because we don't do this.
Like to point it out as
We
well.
don't do this personal introspection as to what's my bias. And if we don't do this, each one of us, how can we, maybe you've discussed all the diversity points. I've never had the situation where it was on the table that we had a panel, a pool of arbitrators with one of those arbitrators who would be disabled. I haven't been confronted to this situation, but it's a real question that we should all ask ourselves. If we are confronted to that situation, is that going to be an issue? What is going to be our own reaction? I think that it starts before getting to everyone, it starts with us to admit, to acknowledge the fact that we may be biased for many different reasons. It's part of our culture or education or something. Maybe some are less biased than others. We all would prefer to think that we are less biased than others, but I think that the work starts with us. And that is a question, is that how do you do this without raising your own criticism on everything you're doing? So I think there's a lot of thinking here, but it's true that we're always looking at others when we should first really start looking at ourselves and deciding what is important. Where do I start?
Yes.
I heard you, and I had a test one day with an association who was trying to see with small questions how implicitly we had some bias, and I think this is something we need to start now. And your speech was very inspiring on this.
So Arbitral Women has put together a very interesting toolkit on unconscious bias, and if you haven't done the training, I suggest you do because it's very mind-opening. About our own biases as well. I think Raphael had a question.
Yeah, I have one question and one comment. Thank you so much, Mélanie. You raised one of the most important issue, I think, which is quality versus diversity. And
Yes.
this remains one of the key, argument for opponents to diversity. How can we fix this? How do you think, Mélanie, we can increase the perceived or the real quality? And how can we get people from outside the establishment, outside these, as you say, middle-aged or elderly men pool, to get some people from outside of Europe, outside of France, UK, the US, become visible arbitrators and more women? How can we do that today?
Yes. Well, it's the essence of the issue. I think the easy answer is get rid of party appointments, get to institutional appointments only, but I don't think that will be a very popular solution. But it's true. I mean, in my experience sitting with arbitrators appointed all by an institution, decision-making is 9 times out of 10 much easier and faster than with a tribunal composed of party-nominated arbitrators. the nice thing about sitting as arbitrator is that you meet people from all over the world, and there are great surprises that, people that I had never heard of, I had never met in my life. You start to work with them and they bring to the table an amazing perspective and very good insights, which, on myself or with the other arbitrator with whom I had worked before, we would never have come up with. So I think it is really a question of opening your mind and making an effort to go and look, be part actively of this international arbitration world, make connections, go and research, reach out to people. We're doing it now. Tomorrow we'll have the meeting of the ICC Commission on the arbitration and ADR. We are in the middle of a huge diversification effort in that context too. And we are trying to go out, and we make a real effort in reaching out to the people in other regions to see what we can do together, whether we can work together. So I think it's not easy, it takes effort, but there is lots of quality in Africa, in Asia, in South America. There are lots of people who are excellently educated and have great professional experience. We just, we from our perspective here sitting in Paris today, we need to make the effort to go out and vice versa. We have the means to be connected and to work together. Let's use them.
On that note, I think I'm looking at the clock, and the ICC conference is starting shortly. Mélanie, we're incredibly grateful for your time today and for your inspiring speech and your call for action. Thank you. Thank you all. Thank you to my co-board members. Thank you all for dialing in, tuning in this morning. This video is going to be available later on the day. I'm not suggesting you watch it again, but you can tell others that they can join us. We look forward to seeing you tonight at the opening cocktail and welcoming you in person in Paris. Thank you very much.
Thank you.